Hey everyone! So, imagine this. You witness a crime, you give a super detailed statement to the police, and you think, great, I've done my part. But what actually happens to those words you spoke? Is that statement a game changer that can seal a conviction in court, or is it just another piece of paper that gets buried in a file? Today, we are going to demystify the entire journey of a police statement, all the way from the street to the courtroom.
So let's get right to it. Is a statement given to the police a smoking gun, or is it a legal landmine? Well, the answer isn't a simple yes or no. See, it's wrapped up in this whole web of rules that are designed to do two things: protect the investigation, but also, crucially, protect the rights of every single person involved. So let's unravel it together.
We're going to follow the complete journey of a statement. We'll start right at the beginning, where it all begins, the investigation. We'll look at how police can call in witnesses, the exact rules for how a statement is recorded, and then we're going to tackle that million-dollar question. What is it actually worth in court? I promise, by the end of this, you'll have a rock-solid understanding of this for your exams and beyond.
Okay, before we can even talk about a statement, we have to understand the world it's born into, the police investigation. And this isn't just some random chat, It's a formal process with its own set of rules and a very, very specific goal.
Under the new Bharatiya Nagarik Suraksha Sanhita, or BNSS, as we'll call it, which has recently updated our criminal laws, an investigation, or unvation, is defined with one purpose in mind: the collection of evidence. That's it. Think of a detective building a case, brick by brick. Every question they ask, every search they conduct, that's another brick in the wall, all aimed at finding the facts.
So what does that look like in practice? Well, the Supreme Court, in the really important case of H.N. Rishid v. State of Delhi, basically gave us a clear roadmap. It's like a story that unfolds in 5 parts. It starts at the crime scene, then moves to figuring out what on earth happened, then finding the suspect, and then, you see it there, step 4, comes the collection of evidence. This is where our statements come into play. The final act is the decision. Is there enough here to actually go to trial? Okay. So the police are building their case, and now they need the most important bricks of all, information from people. But can they just force anyone to come and talk? Let's take a look at the legal power they have to summon witnesses. The legal muscle behind this power comes from Section 17(9) of the BNS. You could think of this section as the official invitation to the police station, and it's an invitation that you can't really say no to. But, and this is so important, this power isn't a blank check. The law builds in a crucial shield for the vulnerable. A woman or a boy under the age of 15 cannot be dragged down to a police station. Instead, the police must go to them, to their place of residence. This is a fundamental safeguard that recognizes that there can be a power imbalance in these situations.
All right, so the witness is now face-to-face with the police, either at the station or at home. So what happens next? This isn't just a casual chat. There's a very specific set of rules that both the officer and the witness have to follow.
This entire process is governed by Section 180 of the BNSS. This section is all about making sure things are fair and creating a reliable record of what was said. It really sets the rules of the game.
Now this shows the delicate dance between rights and duties. On one hand, you are legally bound to answer truthfully. But on the other hand, you have a fundamental right to remain silent if an answer could get you into legal trouble. This is the legal system's way of saying, look, we want the truth, but we will not force you to condemn yourself. And here we are, the heart of it all. All this procedure, all these statements carefully recorded. What happens when they finally make it to the courtroom? This is the moment where all the steps we've talked about either pay off or, well, they fall flat. So, can a prosecutor stand up in court, hold up that statement, and say, "Case closed, Your Honor"? Is this piece of paper, recorded under Section 180, the final word? The short, direct, and most critical answer is an emphatic no.
Well, generally, and there's a really powerful reason for this. You see, the law has always been suspicious of statements made in the high-pressure environment of a police station. It's wary of potential coercion or pressure. The whole principle is that real evidence has to be presented and tested out in the open, in a court, under the watchful eye of a judge, not behind closed doors.
And it is absolutely vital to understand the difference between two things here. Think of a witness statement as one piece of a jigsaw puzzle. A confession from an accused person, on the other hand, is like the picture on the front of the box.
The law is way more careful about accepting that box picture from the police, because if that confession was forced, the entire case could be built on a lie.
Now, this is a classic trick question that comes up on exams and it trips up a lot of students. So let's clear this up once and for all. The law says a witness statement isn't supposed to be signed. But what if it is? Does that just make it completely useless?
The Supreme Court settled this beautifully. A signature doesn't automatically kill the statement's value, but it does raise a big red flag for the judge. It forces the court to pull out a magnifying glass and look really closely at that statement and ask, wait a minute, why wasn't the standard procedure followed here? Was there any pressure on this witness?
So if these statements aren't direct evidence, are they just filed away and forgotten? Not quite. There are a few very specific and highly controlled situations where they can make a really dramatic entrance into the courtroom. These exceptions are all laid out in Section 181. The first one, and the most common, is for contradiction. Imagine a witness says in court, the getaway car was blue, but in their police statement they said it was green. A lawyer can use that statement to say, hold on, you're changing your story. The second use is to then explain that contradiction. And the third, and most tragic exception, is if the person who gave the statement dies, their words could potentially be admitted as a dying declaration.
Wow, we've covered a lot of ground, haven't we? We've followed a statement from just a simple conversation all the way to a complex legal document. So what are the absolute must-know takeaways from all of this? Let's boil it all down.
Here's the bottom line. A police statement is a tool for investigation, not a weapon for conviction. Its main job in court is to keep a witness honest. The entire system is designed to make sure a person's fate is decided by what is said and proven in the open courtroom, not in the confines of a police station.
And this brings us to the final, crucial question that underpins all of this. All these rules are about striking a really delicate balance. On one side, police need the power to investigate and solve crimes. On the other, citizens need their fundamental rights protected. The journey of a simple statement shows us just how complex and how vital that balancing act truly is. It's a question that every student of law and, really, every citizen should think about. Thanks so much for joining me.